Can we have anybody and everybody taking stock of our sensitive personal data? What all protection mechanisms are provided for the personal data? Are there any details that are covered in data processing, personal data breach, and significant data fiduciary kind of terms? Does the consent form an important ingredient for the use of personal data in any form? We shall look at all these points and more in this video. Welcome to my channel, aka the TME. For those of you who are new to my channel, I have already covered some of our terms in our previous video. The video is already available and I am providing the link in the description below. Looking at the recap, we pretty much covered the enactment, scope, preliminary in our first part of the video. To understand better and in detail, you can refer to the link below since we will like to focus more of our time to newer coverage in this video. So let's begin. All these definitions are already covered in the part 1 of the video, which is already uploaded. And before we begin, a request, please click this like button on this video and subscribe and share. It motivates us to put more energy to cover the content in detail for the benefit. Now let's begin with newer definitions in this video. We're looking at section 2 subclause O gain, which means 1. A gain in property or supply of services, whether temporary or permanent, or 2nd, an opportunity to earn remuneration or greater remuneration or to gain a financial advantage otherwise than by way of legitimate remuneration. The American idea of fair information practice, which Alan Weston articulated in a chapter of his landmark book, Privacy and Freedom, is where data protection law got its start. According to Weston, the right would resemble a property right in which you own data about you. As per him, helpless individuals give their personal information to businesses and governments in order to receive essential services and lack the knowledge or meaningful opportunity to impose the terms under which their information is to be used after being collected. So, under a property regime, you own the data about you, which means that anybody wanting to collect, use, or transfer your data will have the burden of obtaining your consent before using it for any purpose or sharing it with any third party. The subclause P, loss, means 1. A loss in property or interruption in supply of services, whether temporary or permanent, or 2nd, a loss of opportunity to earn remuneration or greater remuneration or to gain a financial advantage, otherwise than by way of legitimate remuneration. Contrary to gain, as we looked in subclause O, the loss denotes a separation from personal data, either inadvertently or one's own negligence. Probably it could also mean interruption, loss of productive hours due to unforeseen situations such as linked down, productive hours, loss due to network unavailability, a ransomware attack, or any other man-made or unexpected technical glitch, all of a sudden due to which the data principal suffers because of the one or following ways. It could be either a loss of control on personal data or an opportunity to earn or gain financial remuneration. The subclause Q, member, means a member of the board and includes a chairperson. Now, if we interpret it, it basically refers to the member of the Data Protection Board of India and includes chairperson as per the Act. Not much to add in here since it's pretty much simple in understanding. Let's also look at the subclause R, notification, which means a notification published in the official gazette and the expressions notify and notified shall be construed accordingly. So it basically implies all the words which are indicated here. The subclause S, person, includes 1. An individual, 2nd. A Hindu undivided family, 3rd. A company, 4th. A firm, 5th. An association of persons of a body of individuals whether incorporated or not, 6th. The state, and 7th. Every artificial juristic person not falling within any of the preceding subclauses. So it lays emphasis on defining person for the purpose of this act. A person could be anybody who is listed here on the screen. We are looking at subclause T, personal data. This means any data about an individual who is identifiable by or in relation to such data, as the definition says laid down in the Act. Now, if you have to understand personal data, it is important to understand we have been talking about personal data. It throws some light on the interesting aspect and the background which has a reference to Shri Krishna report in 2018 that highlighted the importance of personal data must be covered in legal framework, and certain categories of personal data which were importantly classified for an individual be segregated as sensitive personal data. Some suggestions made by report are as follows. 1. Data will be defined as per the standard of identifiability. Second, such data processing by public and private entities be covered under law. Third, following data can be classified as sensitive personal data, as it is very, very important and sacrament to identification of an individual. Here is the list. We have passwords, financial data, health data, official identifier, biometrics, sex life of a person, genetic data, and the data concerning. Later on, some objections were there from the entities and on the data localization, and it was proposed that the sensitive personal data will be processed within the boundaries of India and that central government alone will be deciding in this regard. Furthermore, we saw personal data related to health was also allowed in case of emergencies. Subclause U, personal data breach. It means any unauthorized processing of personal data or accidental disclosure, acquisition, sharing, use, alteration, destruction, or loss of access to personal data that compromises the confidentiality, integrity, or availability of a personal data, which is basically the CIA framework as laid down by the cyber securities. So this is simply to put down, it means any unauthorized processing of personal data or accidental disclosure of the data or unauthorized acquisition or unauthorized sharing or unauthorized use or alteration or unauthorized destruction or loss of access to personal data that compromises the CIA. Basically, the Act lays down important guidelines and regulations for processing of personal data with consent only of either the data principal or the data fiduciary. As the subclause V, prescribed, as the definition says, means prescribed by rules made under this Act, and subclause W, proceeding, means any action taken by the board under the provisions of this Act. Let us look at the subclause V first. It implies, as per the oxfordreference.com, there must be a legal regime governing the interference in question. That law must be both adequately accessible and with sufficient precision to enable citizens to regulate their conduct. This is as per the rules under this Act. And if you look at subclause W, means incidental. I'm quoting the lawdictionary.org. The term applied to a course of action that comes from the main action or proceeding, or proceeding ordinary, that is the term that is used for a suit that is carried on in the usual manner. Subclause X, processing, in relation to personal data, means a wholly or partly automated operation or set of operations performed on digital personal data and includes operations such as collection, recording, organization, structuring, storage, adaptation, retrieval, use, alignment or combination, indexing, sharing, disclosure by transmission, dissemination or otherwise making available, restriction, erasure or destruction. Now, interestingly, we have been looking into the personal data. We looked into the entities like data principal and data fiduciary. It is also very important to understand what processing is. There is an implied obligation on the data fiduciary to process data. We discussed on data fiduciary in part 1 video. You can watch it again. I'm sharing the link to the video in description. So the implied obligations will be on the fiduciary, like 1, the personal data to be processed in a fair and reasonable manner and should not conceal the privacy unless required by law. 2, processing to be in manner that is comprehensive and correct. 3, limitation of personal data that is only for the specific purposes and the specific time period. 4, transparent necessary information to data principal about collecting of the personal data. Going forward, when we see all these terms like operations such as collection, recording, organization, etc. These are a bit of technical processes, and till the time we don't understand what exactly each one of them will entail along with an example, we will not be actually clear how the processing will impact or have an obligation towards the data fiduciary. I'll make a detailed video only to explain this subclause X processing, and then I'll upload that. In subclause Y, she, in relation to an individual, includes a reference to such individual irrespective of gender. Subclause Y word, she, instead of he, indicates women are leading the legislation making process, the important roles that they play in the parliament, and thus lawmaking. Subclause ZB, state, means the state as defined under Article 12 of the Constitution. And the Article 12 of Constitution states in this part, unless the context otherwise requires, the state includes the government and parliament of India and the government and the legislature of each state, each of the states, and all local or other authorities within the territory of India or under the control of the government of India. Subclause ZA, specified purpose, defined as it means the purpose mentioned in the notice given by the data fiduciary to the data principal in accordance with the provisions of this act and the rules made thereunder. If you look at this subclause, it states very clearly that the specified purpose is means for which the consent is taken from data principal by data fiduciary, after which the data cannot be processed once that purpose is over. For example, a person submits his personal data to a shopping website, including his PAN and Aadhaar card and other details like address, PIN code, etc. The data for the purpose of shipping, which is name and address itself, is sufficient, leaving aside the PAN and Aadhaar ID. But since he is registered with the company or the website, providing all his details, it's a duty of the website or the company to not let the loss happen to the data principal even after the transaction is over. Subclause Z, significant data fiduciary, means any data fiduciary or a class of data fiduciaries as may be notified by the central government under section 10. And as you can see on the screen, we have listed the subclause 1 of section 10. This we will cover when we cover section 10, but for the time being it is important to understand the definition in subclause Z and subclause 1 of section 10 define the additional obligations of data fiduciary. In that, it will be solely responsible for processing of personal data of data principal. The other important point is that it can be notified by the authorities with regards to processing the data. The video and the content covered. Do subscribe to the channel for the new updates and hit the like button